record. I'll just formally introduce it and announce it. Hello everyone, it's Simon Fisher here, the course coordinator for Administrative Law, Laws 12061. This is the fifth session for considering some of the tutorial problems in the course. Today we'll be considering problems 21 through to 26, and that should wrap up the tutorials. We'll need to be fairly businesslike about getting through these 6 problems. They're not especially difficult, but it just means I'll sort of have to march our way through it. I don't mind questions from anyone who's participating as we go through, so by all means jump in and ask one, and I'll do my best to answer it. And now, if we look first at problem 21, and the part of the course that problem 21 is anchored in or situated in is in fact the question of merits review. Now again, we've got a problem question, and I guess you've all had a chance to read it and to at least indicate some thoughts for yourselves as to where you think, what do you think the answers to this problem are. Now, note that if this was an exam question, note in particular paragraph numbered 5 of the problem, because it tells us that the department has decided to appeal against this decision, arguing that, and there are 5 bullet points that I actually refer to. So if you were answering this question in an exam, you would actually need to deal with those 5 bullet points to get an accurate answer or a comprehensive answer. The other thing to keep in mind too is that when you're asked to advise somebody about advise X or Y or something like that, not only do you need to give them the advice that they want to hear, that is whether they will succeed or not, but you should also argue, look at the competing arguments, so argue for or against a particular position. And that's particularly so in this problem when you've got a situation where the department is contemplating an appeal and it trots out 5 subpoints as the basis of its appeal. So what you need to do on each of those points is consider the arguments for and against each of those propositions. All right, so in a sense, a question like this is quite helpful for us as budding lawyers, because what it does is it tells us, it gives us the signpost we need to use in order to give the advice. So the overall question, and always keep this in mind, is the department wants to know, would its appeal be likely to succeed? Now, I might just interpolate parenthetically and say that in the administrative appeals setting in the federal arena, although it's usual for citizens to initiate appeals, on occasions you can in fact have departments who do appeals, and that's not uncommon in areas such as, for example, social security law, where often the department is the applicant and the individual or citizen is the respondent. But by and large, in most cases of merits review, a government department or agency makes a decision that somebody is not happy with, and it's that somebody, that person aggrieved, who then initiates the appeal. So don't get confused about the fact that here the department is the appellant. It certainly is possible, both in theory and in practice, for a government agency to initiate an appeal to the AAT. All right, apart from that commercial message, let's look at the first question, or the first part of problem 21, which is the question, does the AAT have jurisdiction? All right, now, the first thing you always need to be aware of when it comes to merits review is that most of the statutes, and that includes Queensland's QCAT, and also for that matter the AAT, merits review is a statutory creature. It doesn't exist at common law. So you always look for an enabling or conferring statute. So that's the first thing you must look for in a question, is whether or not there is a statute conferring jurisdiction. So if there is, well and good, it's probable that the tribunal has jurisdiction. If not, then there is no jurisdiction, and the answer would be in the negative. Now, if you had an exam question where that matter was not explicitly addressed, and it might be for very good academic reasons, you should argue in the alternative. So you might say, initially, there's no evidence that this particular statute confers jurisdiction on QCAT or the AAT. That almost ends the question. But it's a bit more subtle than that. You also need to consider, well, perhaps the reasonable examiner has taken the view that they want you to think about it. So you would argue in the alternative and say, look, in the event I'm wrong on jurisdiction, let it be assumed that the AAT does have jurisdiction, and accordingly we will proceed as if there is a statute confirming jurisdiction on the relevant tribunal. So don't forget to argue in the alternative if the facts are silent or otherwise not terribly clear. All right, now coming back to the substantive question about does the AAT have jurisdiction? All right, and again, remember that this problem takes us back to the infamous customs prohibited import regulations that we saw in the very first problem. All right, so the first thing you need to think about is what if anything, do the facts say about the whole situation? And in a problem like this, you're given a couple of critical dates. You're told that on the 1st of April, Justina left the AG's department. And so, in other words, her employment, it says on the facts, she retired, i.e. left the department, no doubt to take up a lucrative position with a large law firm specialising in government legal work, probably Clayton Utz. Or secondly, and also on the facts, you're told on the 4th of April, she read the shock treatment file and then made a decision. So we've got a situation where you have a purported decision maker, making a decision after her term of office has ended. So that's something that's going to be a signal that you have to do something on the facts. All right. Okay. Now, coming back to the question of jurisdiction, it's a bit of a tricky issue actually in this case. We know that under the Customs Prohibited Import Regulations, that under Subreg 5, 4 and 8, there's always the possibility of a certificate being issued by the Attorney General to preclude merits review. Now, our facts don't say anything about this, so the way we would treat it for the purposes of an exam at least is we would make an assumption that the Attorney General has not issued a certificate precluding merits review. So as the reasonable examiner, I would want to see at least that being mentioned in passing in your answers to this question. Now, the other thing to also keep in mind is the general law dealing with when people do things, particularly delegates. And just be aware and have a look at section 34 capital B, sorry, withdraw that, section 34 capital A capital B of the Acts Interpretation Act 1901. And just be aware that when a delegate exercises a power, it's deemed to be an exercise of power by the repository. And the repository here is the Attorney General. So in other words, what the delegate does is taken in law to be an act of the Attorney General himself or herself. Now, the other thing that's a bit tricky in this case is that we have to ask ourselves, was Justina Darling an authorised person at the time when she made her decision? And also we have to make an assumption that she was probably a delegate of the Attorney General for relevant legal purposes. So what we've got then is we've got the problem that young Justina has actually made a decision 3 days after she in fact retired from her role in the Attorney General's department. And the facts are silent as to whether she was authorised after that date or not. So a cautious or a prudent answer from a student would say, look, we'll assume conservatively that she wasn't authorised, and so that would therefore mean the AAT has no jurisdiction to entertain an appeal. However, you would also argue in the alternative that if you're wrong on that point, and somehow Justina's delegation might live on to enable her to finish a task she started, then it might be the case that the AAT does have jurisdiction. Now, the other thing that those date sequences also throw up is the fact that if there's any doubt about what the kind of decision is after the 1st of April, what we've in fact got is it might in fact be what we classify as a purported decision. So if it's a purported decision, the question then is, does the AAT have jurisdiction? As it turns out, there is in fact some case law on this. Have a look at the case of Collector of Customs, New South Wales against Brian Lawler Automotive, reported 1979, 41 FLR 337. And in that case, the full court of the Federal Court ruled that the AAT has jurisdiction to hear an appeal from a decision which is a nullity, because the word decision in the AAT statute was read as including a purported decision. So in other words, a purported decision, or a Clayton's decision if you prefer, is in fact a decision for the purposes of the statute. So, so just be aware, a purported decision can in fact be the subject of a valid or competent appeal to the AAT. Now,
I'll just ask a question.
Sure.
Why does a purported decision even need to be reviewed? Why is it just not an invalid decision?
Hang on a moment. Sorry, I just got interrupted then. Your question was, Terry, why is it a decision at all? Is that what you're asking?
I mean, yeah, if it's a purported decision,
yep,
in so much that it's a void decision,
yep,
why would you even need to seek a review on it? Why don't you just have the grounds to say you can't make that decision? Okay,
well, the reason why somebody might want a decision as to whether something is or isn't a decision is because now this is the mirror of what we're dealing with on this problem. Normally it will be a citizen who's upset about a decision made by a government department. So a decision might be made denying a benefit or refusing an exemption or whatever it is under the relevant legislation. That citizen might say, well, that decision's wrong. I need to take it to the AAT so that they can actually make a pronouncement as a matter of, at least binding opinion, that it's not a valid decision. So that means the government department would then be forced to recognise that the decision it thought it made is in truth no decision at all. So that's probably why you might take a purported decision from a government department up to the level of the AAT. Because you want to recognise that there is no decision.
Okay.
Now,
so you're really not asking for a review of a decision, you're asking for a decision to be made on whether it's valid or not.
Yeah, that's right. That's right. Okay. And the only drawback with the AAT doing that is that the AAT is not a Chapter 3 court within the meaning of the Constitution, and the AAT can only at best make fairly persuasive opinions as to what the law is on a particular point, because don't forget, it can't exercise judicial power. So that's the only drawback to going to the AAT. Although this isn't the problem, in our case, in this problem here, if there was any doubt about it, the other thing to do would be to take proceedings under the ADJRA and ask the court to make a declaration that the decision that you don't like is in truth no decision at all. So that's the alternative pathway, and that would be judicial review on the basis of a legal error.
So if you went to a tribunal and sought, thought a decision that it was a purported decision, and the tribunal was, but the decision maker continued to apply the decision, could you then use the findings of the AAT as evidence in a claim, in an action under the ADJR then?
Yes, you could. And that might be, in fact, your only remedy, because although it's quite unusual for both at state and federal level for a decision maker to ignore a decision made by a body such as either QCAT or the AAT. In fact, I don't know, certainly on my time on the AAT for the 5 years I sat on it, I cannot ever remember a government department not following one of my decisions. Occasionally they were appealed to the federal court. That's a different question. But if they don't appeal it, then the government department is obliged to apply or implement it.
But isn't the AAT, that's not binding, isn't it?
Sorry, the decision, actually, in terms of the decision, it does in fact bind because it binds the government department and it binds the applicant or the two parties to that dispute. So we have to be careful about what we mean by binding or the bindingness of a decision. The decision will bind the parties to it because the AAT statute says effectively that the tribunal stands in the shoes of the decision maker. So it's making a fresh decision de novo or again. But as a matter of law, the status of an AAT decision doesn't create binding precedents, although some of the decisions of the AAT have been extremely influential and get cited outside of the AAT because they are regarded as very good and clear expositions of the law. A good example of that is that very famous case, Drake against the Minister of Immigration. That's always cited in other tribunals and outside of the AAT itself as an instance as to when tribunals are or are not bound to follow government policy. All right, so coming back to the first question about jurisdiction, you could argue in this case that the purported decision is in fact no decision at all, therefore the AAT has no jurisdiction. But I think that's too cautious a view. I think the Collector of Customs in Brian Lawler case says that the AAT can have jurisdiction to review even a purported decision. So applying that to the facts, even if Justina's decision is in fact a purported decision, that is in law possibly no decision at all, it can still be reviewed by the AAT. So I would probably think cautiously that the AAT would have jurisdiction. Now, the second question we're asked, and remember we're looking at those 5 bullet points, the department decides to appeal against the decision, arguing that number 2, having acknowledged the correctness of the primary decision, the tribunal acted perversely in departing from it. The way we dress that up in legal terms is that we say, did the tribunal err or make an error in departing from the original decision? So in other words, the question for us to consider is, must the tribunal follow the original decision below? And that's a question that basically says, first thing you have to do is look at what is the jurisdiction of the AAT, what is its role to do. The mantra that comes up time and again in the case law, in particular that famous case of Drake and Minister for Immigration and Ethnic Affairs, is that the mantra or the mandate of the tribunal is to reach the correct or preferable decision. So that's its key role in any particular case. And consequently, you have to ask yourself, does the tribunal, does it have to follow a decision made by the government agency below? And the answer is no, it does not. So, if you look at Drake's case, the tribunal is free to disregard the decision below, frequently does. There were many times when I decided cases on the AAT that I did not follow what the government department below had done. Equally, there were times I thought they were right. But the mantra that we had to obey was we had to reach the correct or preferable decision on the evidence before us. The other thing that also keep in mind with merits review, particularly the AAT or QCAT, is that tribunal is entitled to act on different material. So in other words, there may be more material in front of a decision maker or an adjudicator at the AAT level than the government department had in front of it. So that might be a reason why a different decision should be reached. And whether that different material or new evidence is handled properly, that's a separate legal question. And in fact, that comes up in the third point that we'll look at in just a moment. So So to wrap up that second point about the question of error, it would be my view that the AAT did not act perversely in departing from the original decision, as long as it directed its efforts to reaching the correct or preferable decision within the formulation from Drake and Minister for Immigration and Ethnic Affairs. All right, the third question as part of this first problem is there any kind of error where the AAT solicited the advice of a non-expert? Now, again, you have to look at the facts. What do the facts tell us? If you look at paragraph numbered 2, it says, so one of the members of the tribunal, the AAT, rang up a person she knew in the Department of Politics at La Trobe Uni, and that person gave some advice about shock treatment. Now, I appreciate it's a problem question. In practice, no tribunal member would actually do that, but we're told on the facts they did, so that's the thing we have to live with. The first, but at least in legal terms, is you have to look at how can the AAT discharge its functions. All right, first thing to remember is that under Section 33 of the AAT statute, the tribunal isn't bound by the rules of evidence. Now, in saying that, that's clearly what the statute says. But in practical terms, you need to be aware that the AAT certainly follows the rules of evidence fairly closely. While it may not be bound by them, basically most hearings are conducted on the basis that the rules of evidence do apply. And in the federal arena, that's the Evidence Act 1995. Technically it doesn't apply to the AAT, but in the common law principles expressed in the law of evidence and also the statutory rules in the Evidence Act 1995, Commonwealth, in practical terms they follow fairly closely. And certainly it was my practice when I sat on the AAT that by and large we followed, or certainly I followed the rules of evidence, and I never got rolled on appeal for doing so. All right, so that's the first thing to keep in mind. The other thing that's also important is the AAT has to accord procedural fairness under Section 39 of its statute. In other words, the rules of natural justice have to be extended to both the government department and also to the individual or person challenging the government decision. So the tribunal is bound to accord natural justice or procedural fairness to all parties before it. Now, that comes back to this question of the so-called lecturer at La Trobe Uni having provided some views. Now, if that lecturer isn't an expert, then the AAT wouldn't give that person's views a lot of weight. So that goes to the quality or nature of the so-called evidence. But the question isn't the value of that evidence, it's whether the tribunal itself has accorded natural justice to the Attorney General's department. So the question then becomes, has any kind of legal error been committed by the tribunal in getting that evidence about the shock treatment film from the La Trobe University so-called expert. And my view is that there has been a denial of procedural fairness, because if the tribunal is going to make that inquiry, then the fruits of that inquiry should be exposed to the parties, and then those parties should be invited to make submissions or to argue against, or even to lead evidence against the proposition that the shock treatment regime could work. So that's, in my view, a legal error committed by the tribunal in that case. In practical terms, the way it would be dealt with is if there is some fresh material that a tribunal member becomes aware of, what would happen in reality is that tribunal member would reconvene the hearing. The tribunal member would indicate his or her concerns to the parties concerned. There might be documents to be provided by the tribunal to the parties, and as necessary, a resumed hearing would take place where the parties have an opportunity to contradict that evidence by leading their own evidence. So in reality, that would never happen. What's happened on these sanitised facts, and that's how it would be dealt with in practice. Now, the fourth question in this problem is the department appeals, among other grounds or reasons, saying that while the tribunal was not required to act in accordance with government policy, it was obliged to give it some weight. And the question is that correct as a matter of law? Now, the AAT said very early on in its existence, in the famous case of Drake and Minister for Immigration and Ethnic Affairs, that government policy does not need to be followed slavishly. And I can certainly remember many cases where the government would argue that they had a certain policy on a matter and that as a tribunal member I should follow it, and my reply was also always, well, I'll think about it, but I'm not bound by it. So that's actually quite good from a basis of merits review, because it means that government policies will be considered, but they're not determinative or given excessive weight. So just be aware that as a matter of law, government policy can be followed, but it's not required to be followed. Sometimes it's a matter of good administration, as it was said in Drake. Government policy should be followed in a particular case, but as long as we don't do so slavishly, then there's no legal error committed. And then
Is that because it's not legislated?
Sorry, say again?
Is that because it's not legislated? Or,
partly,
the policy?
It's generally rare for policies per se to be legislated. You tend to have more concrete things like rights and obligations and stuff like that that tends to be legislated, and the policy is a way of doing things that sits behind the legislation. So unless that's a good question. If the policy is legislated, then more or less it will be applied, because the tribunal, like every other legal actor, has to follow the law. But if the policy is not expressed in an appropriate legal standard in legislation or in subordinate legislation, then it doesn't need to be followed. But it certainly should be given appropriate weight according to the circumstances of the case. Mm-hmm. Then the fifth point to consider is, if the tribunal had doubts about its decision, it should have deferred to the government, which had no doubts whatsoever as to what was right. In other words, that's a question of does the tribunal have to defer or yield to the government given its doubts? All right, now again, come back to what the AAT has to do. It has to reach the correct or preferable decision, and so there may or may not be a correct decision in any particular case, but the mantra the AAT follows, it has to reach the correct or preferable decision. So as long as you can sustain on a basis of reasoning a preferable decision, then the tribunal's decision will be correct as a matter of law. Because if you think about the difference between a correct decision presupposes only one decision can be made on a set of facts. A preferable decision, on the other hand, presupposes that there's a range of choices available to a decision maker or an adjudicator about what kind of decision should be made. So the short answer is, if there's a preferable decision, then it's more likely than not that the tribunal, the decision of the tribunal will be more or less bulletproof when it's taken on appeal.
Just a quick operational question.
Yep.
Would the department be appealing to the appeals division of the AAT in a matter like this?
No, it'll go to, I think it'll go to the general division. I can't remember anymore I think it goes to the general division. There are several divisions. There's the Veterans Division, Taxation Affairs Division, Security Appeals Division. It'll just go to, I think, to the General Division of the AAT, but the registry will always allocate it to what it thinks is the correct part. But most of the tribunal members sit in most divisions. The only one I didn't sit in was the Security Assessment Appeal, where you had to be a member who'd been a previous Army officer.
So in this case, like the first decision of the AAT,
yep,
is made by a tribunal member.
Yes, there's no, unless it's provided for in legislation. There's no multi-tiers to the AAT. It's different to QCAT. QCAT in Queensland has like the first tier of review, and then it has an appeal division inside QCAT. So,
okay, so AAT doesn't have an appeal division inside.
No, it doesn't. It's a single. It's either a single member, or in many cases you have a multi-member panel who constitute the appeal. For example, in cases involving medical issues, your typical composition for an AAT panel is a legal member and probably a doctor as well.
Okay.
So you might have two people. Sometimes you might have someone who's had previous Centrelink experience in, say, a social security appeal. So you might have a 2 or 3 member panel. I sat on quite a number of multi-member panels, but most of the decisions I decided in the AAT were single members, particularly for tax cases and things like that. I would just be sitting alone deciding those cases. All right, so
I've got another question.
Yeah.
Hello?
Yes, I can hear you.
If the government makes, like if you go make a decision against the government,
yep,
can the government appeal, and can you be penalised? Can the tribunal be penalised?
No.
Going against
the answer to your second question is no. The tribunal members have relative independence. The real sanction is if you had a member who kept making decisions the government didn't like, is that they wouldn't reappoint them. Your members are appointed for either 3, 5 or 7 years. The government would just wait till the end of their term of appointment and not reappoint them. You can't be sacked except for proven incapacity or misbehaviour, just like normal judges. So they've got sort of reasonable security of tenure. But the first part of your question was, if the government doesn't like a decision, I think it's wrong as a matter of law, they take it up on an appeal to the federal court under Section 41. So if the government doesn't like your decision, they appeal it. I got appealed a couple of times. I think I got rolled once by a particularly narky federal court judge who seemed to delight in overturning anything from the tribunal. Anyway, won't go there. This is me being bitchy. All right. Okay, so to wrap it all up for question 1, it is quite likely that the tribunal will have been found to have denied natural justice or procedural fairness to the government because of the getting material from this stranger at the La Trobe University. So that would be enough to justify an appeal on the question of law under Section 44. What would happen on appeal is that the federal court would say the appeal is allowed, and then it would remit the decision back to the AAT for a different member to decide the decision. And so the hearing would happen again without that offending evidence coming in. And quite often, in my experience, the federal court, if they allowed an appeal, would send it back to the tribunal with the direction that the appeal be reheard by a member other than the member whose decision was appealed to the court. That's pretty standard across tribunals when you've got appeals between tribunals and courts.
Well, a quick question on that evidence.
Yep.
If it was remitted back to the AAT,
yep,
you're saying that evidence would have to be put aside, but the only reason that the issue around the evidence came up is because the department wasn't given notice of that evidence.
Yep.
Could that evidence still be adduced and let them counter it?
Yes, it could be, and probably the applicant would adduce it, And then
Yes.
the department would then try and have the opportunity to contradict it by leading their own evidence to the contrary. They might get another panel of experts to give evidence that completely overwhelms this quasi-expert from the tribe. So yes, it depends. Yeah. I mean, if the evidence is pretty weak, second time round you probably wouldn't lead it. You'd formulate an assessment as to how good or how weak the evidence is, and if it's pretty poor, I think you wouldn't bother leading it on the second occasion.
But on the first view of the question, the question is not so much as to the quality of the evidence, is it? It's about the procedures followed.
Yeah, that's right. You're absolutely right. The question is about the quality of the evidence, but your question, your supplementary question without notice was, what would you do in a rehearing? And the answer is, you'd either scuttle the evidence completely, or if you're going to lead it, you'd either firm it up, make sure it's good evidence, and the government department would have an opportunity to contradict it by bringing their own expert evidence to pontificate or determine the question of how good this shock treatment regime is.
Yeah.
All right, let's move on to problem 22. I'm conscious of time. I don't want it to run away from us. Okay, again, problem 22 revisits the infamous and notorious Makepeace situation that we've dipped in from time to time as we've gone through the course. All right, now, again, always look at the directive questions in the problem. And it'll be no different in the final exam. The final exam will say, advise X about their prospects of success, or advise Y about their rights and liabilities. So always look at the directive question or signpost in an exam problem, because that is the thing you have to deal with. You're not going to get any marks as a student if you don't answer the question posed. So it's really important in answering the question to actually attend to the question, figure out what it is saying, and then deal with it. Because it's not like, say, doing a mathematics degree where you might get the fundamental premise wrong in answering a maths question in an exam, but your reasoning might be good on every point after that point where you muffed it up. Not that I've studied maths at uni, but people have told me. So the point is, you've got to answer the question posed, not what you think the question is. All right. So our question then is, our direction is, advise Makepeace about its prospects before the AAT. When we talk about the prospects, what we're talking about is the prospects of success before the AAT. And if you're going to advise on the prospects of success before the tribunal, you have to advise about the chances of it winning and the chances of its losing. In my professional practice today, I'm drafting an opinion about prospects of succeeding in a multi-million-dollar case in the Supreme Court. So in advising my client, it's a contractual dispute. Not only do I have to say, these are, I think, the reasons why you might succeed, I also have to think about the reasons why they might lose. So you have to argue both sides of the ledger, so to speak, the pluses and the minuses, if you're going to advise on prospects. Because one of the things we do as lawyers is we evaluate people's chances of winning in a case, or if there's a dispute of some sort. And so you have to argue the toss. It's no good just giving a one-sided diatribe as to why, for example, Makepeace will win, when you might in fact overlook a critical piece of evidence or a critical piece of law that actually says it's going to go down in the screaming heap. So again, the moral to the story is argue both sides of the toss when it comes to the prospects of success. All right. So the first sub-question that really emerges on this particular problem is, if you look at the problem, again, they Makepeace want to argue that this particular book, The Night of a Thousand Shames, is not a prohibited import, and that alternatively, even if it is, they should be permitted to import it. So that part of the question frames what we need to look at. So the first question is, or the first thing to consider is is it open for Makepeace to argue or succeed in arguing that the book is not a prohibited import? Now, if we go back to the prohibited import regulations back in the first problem where they're listed in their gory detail, you need to take particular note of Reg 4 capital A sub 2, which involves a refusal of permission or the granting of conditional permission to import a product that is otherwise prohibited. Now, if you look at that regulation, it doesn't extend to a review of the Attorney General's implicit decision that the book is a prohibited import. So in other words, the question as to whether a book is or isn't a prohibited import isn't actually something that the AAT has jurisdiction over. Really what the critical question is, assuming the book to be prohibited, can it be the subject of an application to the AAT? So it's a question what we call characterisation. How do we characterise or label the particular dispute? And that's a particular skill you need to develop as budding lawyers, because how you frame the question determines how you answer it. So basically, you have to assume that the book is a prohibited import, and so that will really answer the first question in the negative against Makepeace. That is, there's no point Makepeace arguing that the book is not a prohibited import, because that's not something the AAT has jurisdiction over. So once we get to that hurdle, we then get to the second point, and that is, should the AAT make a decision allowing Makepeace to import the book? Probably seems a bit subtle, but just take it from me for the moment that that is how the question of characterisation plays out. All right, so our second major question or inquiry for this problem is, assuming the book is a prohibited import, should the AAT give permission to import it or not? So that's really the decision you want from the AAT, or that's the question you want it to focus on. Okay, so
can you look at the personal interest?
Not really. Sorry, you might in other cases, Laurie, but not for this particular problem, because the legislation basically says when things are or aren't prohibited. So the way the prohibited import regs work is they say certain products are prohibited. You know, might be military goods, child porn, whatever it is. All sorts of things are prohibited. And then the question then is, for example, should a decision maker then allow that prohibition to be relaxed? That's the thing that can be the subject of a decision from the AAT. So it's not so much the personal interest of the person, that's relevant to the second question, but the focus is as to what is the correct or preferable decision if the AAT is being asked to decide whether or not to allow importation or not. Have a look at regulations 4A, open bracket 2AA, and notice that the facts talk about a telephone intercept, suggesting that the importation of the book would promote ill will, and that particular reg goes to the question of Australia's relations between Australia and foreign governments. So that's a relevant matter that is signposted by the legislation. So on review, the AAT has to look at that. Now, again, we know the AAT is not bound by the rules of evidence. So when you look at the question of the illegal taping, the question then becomes, can the AAT have regard to that evidence? Now, I take it probably most of us haven't studied evidence law in any formal sense yet through CQU. You need to be aware, and just take it from me for the moment, that courts have a general discretion to exclude improperly obtained evidence. Now, we're told on the facts that the taping of the meetings is illegal, so it's not even as if we can look at the AFP or some other agency lawfully taping or telephone intercepting calls or anything like that. We're told it's an illegal tape. So the question then is, can the AAT exclude that evidence? And And basically, when it comes to the AAT, the answer is it could. It could rely on Section 33 of its statute to exclude illegally obtained evidence. I remember once I sat on a case where there was some, not illegally obtained evidence, there was some surreptitiously obtained evidence from a private investigator in a federal workers' comp case. The injured worker had been under video, private investigator had videoed that particular person's activities over several months, and the applicant who was applied to the tribunal of which I was sitting was very surprised when the government in their case wheeled out a television screen with a video recorder, and they started playing this evidence, and the case settled very quickly after that particular stunt. They argued that the evidence should be excluded. I refused to do so because it wasn't illegal, and I took the view that the evidence was going to be helpful in enabling me to reach the correct or preferable decision. So a decision like that is a bit of a forensic stunt, but it can actually make a difference in a particular case, and the one I'm thinking of was exactly one of those cases. The lawyers for the applicant were not very happy, let me tell you, but they didn't appeal my decision. Anyway, so...
Yep. Move on. So in this situation here, under that Section 33, even though the evidence may be illegal, because the AAT is not bound by the rules of evidence,
yep,
they could still choose to allow the evidence to stand.
They could. But then that would lead to another legal problem, and that is, should the AAT, on an appeal on a question of law, the question will be framed, should the AAT have excluded the evidence? Because what evidence you admit in a case is basically a question of law. Even though they're not bound by the rules of evidence, what you let in as a matter of evidence can be a legal question. So there may well be a question on appeal that Makepeace would run that would say, look, the tribunal should not have allowed that illegally obtained evidence to go into evidence because it was to admit evidence in breach of a statute that prohibits it is itself a legal error. So there would be a good reason why that why the tribunal would not admit that evidence. And if you had to, yeah, go on.
And that would be an appeal later down the track.
That's right. Yeah. There could be a couple of ways it might arise practically. When that point comes up in this particular hearing, the tribunal would probably conduct a mini hearing just on the admissibility of that evidence.
Okay.
And it would make a ruling as to whether or not the evidence should be in or out. I remember having to do that a few times during my time on the AAT. Sometimes the parties are content to let you make that decision on admissibility as part of the overall case, so that after you reserve your decision and you think about it, you make a ruling along the way as part of reaching your ultimate decision. So there's two ways of dealing with it in practical terms. All right, now coming back to the question about whether permission to import would or would not be granted, certainly I think the illegally obtained evidence would be excluded. And there is some case law. There's a case, I think, Hayes against the Australian Postal Commission. That's always cited, I think, and really it indicates in a policy sense that illegally obtained evidence should not be admitted in a case. And it goes to procedural fairness to both the applicant and to the respondent. So that needs to be considered. Now, if we're looking at the overall question, the larger question, would permission to import be granted? Now, what we are told about is, so I'm just going back to the facts. There's something that leapt out at me that I wanted to touch on. That slipped my mind. Can't remember what it was. All right. Now remember that on appeal, the AAT has to make the correct or preferable decision. And again, it's not bound by government policy, as we know. So the question then is, even if the book is a prohibited import, should it be allowed to import it? The tribunal stands in the shoes of the decision maker below and tries to reach the correct or preferable decision. If we look at the facts, what we've got is the government is quite upset about the funding of the importation book campaign on the part of Makepeace. And just be aware, though, that on the evidence in front of us, that's sort of, there's some dark people in the background. This Diurus Liberation Front, who are dominated by what are said to be animist fundamentalists with a record of terrorist attacks. So the evidence of the funding might be a reason why the AAT might make a decision refusing to import the book. However, does that really go to the question whether the book itself should or should not be imported? One possibility is the tribunal could actually make a decision approving the importation of the book, but if there's anything offensive in it, it could actually order it to be cut out. That's happened, I think, in a couple of cases where, particularly on the freedom of information, where documents are disclosed, sought to be accessed by people. Sometimes what the adjudicators do is say, yes, we'll allow access, but we'll sanitise or cut out the offending bits that they don't like, that they think are not conducive to a correct or preferable decision. So look, I think it's line ball. I would probably think, filling in my waters, that probably the AAT would grant permission, but could also redact or edit the work if there were any particular issues that...
Wouldn't you have to give consideration to whether or not it could stir up violence in the community?
Yeah, that would... Yes, that's a good question. And again, the facts seem to suggest that that's the case. If a work was going to be productive of social disorder, that might be a reason why the AAT might not give permission for it to be imported. On the other hand, there might be passages in the book that can be cut out or excised. So perhaps it would allow importation subject to the offending bits being removed. Because it's unlikely that an entire work would be objectionable per se. There might just be particular paragraphs or passages or chapters that are offensive.
Is there any section in anti-terrorism laws that cover this sort of thing?
There probably is. I don't profess to know much about them. But yeah, your question's a valid one. If you were arguing a bit laterally and you were particularly in for the government, you might say that there are provisions in the anti-terror laws that, for example, there are offences of inciting terrorism, aiding and abetting, counselling, procuring, the commission of a terrorist act. Might be all those sort of things that come into play. Generally speaking, we might be aware of those cases involving the jihadists in Melbourne, where there were criminal proceedings against them for promoting acts of terrorism on Australian soil. So yes, it's possible there might be some gravity from those statutes that might influence this particular decision. And certainly, I would expect the advocate for the government to raise those concerns if I was hearing this case on the AAT. Mm-hmm. All right, so my considered opinion, for what it's worth, is the AAT probably would allow importation of the book. If there are any concerns, then what would happen is offending chapters or passages might be removed or excised from it. All right, now it's 5 to 7. Does anyone need a break before we move on to consider problems 23 and following?
No, I'm not.
Okay, everybody else okay?
Yeah, good here.
Okay,
Yeah.
all right.
All
All right,
okay.
we'll march on. Okay, now our problem 23 is an FOI question. I'll say a few introductory remarks about how to approach FOI questions. Now, federally, we have the Freedom of Information Act 1982, and you certainly need to make sure you've got an up-to-date copy of it because it was amended extensively in 2008 and 9. So don't rely on an old, dusty copy that might be relying in somebody's office. certainly get an up-to-date one from comlaw.gov.au. On the state side, just remember that in Queensland we have completely reformed our FOI laws, and we now have the Right to Information Act, and that's the one you should have. So be aware of reading older texts on admin law, because they refer to the Freedom of Information Act in Queensland, which is no longer operative. It's the Right to Information Act. If you're a skeptic, we call this area of law freedom from information. It's one of those subtleties that people who've been around the system a bit talk about. So, yeah, skeptics say freedom from information. Those who advocate open government talk about right to information or freedom of information. We often say the government lawyers work on a premise of freedom from information, but that's just professional bitchery, which we're all guilty of from time to time. All right, let's have a look at our problem. We're told that Dr. Bartolo applied for his position, for appointment as Director of Victims Compensation Board. He was interviewed by a selection panel, not appointed, and he wants to know can he access information concerning the selection process. Now, just as a practical matter, freedom of information laws are used quite often alongside the normal process of discovery in civil litigation. And sometimes you can get very useful documents from an FOI request. In fact, I can give a personal account of this. I've been advising a barrister who was defamed by a particular government agency when it came to a tender for legal work and probity work. And we didn't find out about the defamation until we made a right to information request. And certain very revealing documents came out from the right to information request that indicated not only had my clients been defamed once, but they had been defamed several times over, and in a number of ways, including memoranda and emails. So, message to the moral to the story is a right to information request can be very, very useful when it comes to getting information for court cases or finding out about your rights and liabilities. So that's a case I'm in the middle of at the moment. All right. Okay, now if we look at our problem, we're told about the Attorney General's Department. Now, not stated explicitly on our facts is this: are we talking about the federal arena or the state arena? And the first thing I would be doing if I was the reasonable student answering this question in an exam is I would make an explicit assumption and say that you're going to either look at it from a state perspective or a federal perspective, or to cover your backsides, you might even do both. Certainly I would, if I had sufficient time in the exam, I would argue both, federal and state. What you would do, practically speaking, is deal with one regime in detail and then have a paragraph or two dealing with the position under the other law. I think in this case, it would be fairly safe to assume that it's the Federal Freedom of Information Act that applies, and only treat the Right to Information Act in Queensland in passing. So as the reasonable examiner, I'd be pretty happy with that approach. But a good student would think about both. Okay, now, if we're going to advise our client, Dr. Bartolo, about how he can access information, the cynics among us will say, well, first he puts money in our trust account before we advise him, but I don't expect you to say that in an exam answer. You might do it for my amusement, but you're not there to amuse me, you're there to answer questions so I can grade you. So, anyway, that's a joke at my expense, actually, so don't worry about that. All right, but let's get on with this. All right, the first thing is, if you're going to talk about information, you have to look at, and we'll concentrate on the FOI Act. I'm just going to reach over and find my copy of it. It is a big statute. Mine comes out of 236 pages, so it's a lot of trees wasted, I'm afraid. Now, what you would do is you need to understand what each of the RTI or FOI statutes do. And basically, what the federal statute does is it promotes access to documents. So in other words, when the problem says how can Dr. Bartolo access information? We're really talking about information in the form of documents under the federal statute. On the other hand, the Queensland statute and also the New Zealand one have a different focal point. They talk about accessing information. And the difference is every document has information, but not every piece of information is embodied in a document. So you understand that distinction? I'll say it again. Every document embodies information, but not every piece of information is embodied in a document. So that's the subtle difference between the Queensland law and the federal law. Queensland law focuses on right to information. Federal law focuses on documents. Sorry?
Is document defined within the legislation?
Yes, it is, yeah. No, it is. It is defined. Also, sometimes be aware of the Acts Interpretation Act. In Queensland, it's the Acts Interpretation Act 1954. It's got there a definition of document. I could probably tell you without any lie at all, that probably in the last year I've had 2 or 3 cases where the question of the meaning of document in the Acts Interpretation Act has come up in cases I've been involved in. So always look at general statutes, you know, Property Law Act where relevant, the Acts Interpretation Act. Those general law statutes often throw light on what something might mean, particularly the Acts Interpretation Act.
Within those FOI acts, it is defined.
Yes, it is. Yeah, there is. And so, obviously, look at the general interpretation section is section 4, and it goes into excruciating detail, defining the key terms. I'm just turning it up now, and there is a definition of document in section 4, and basically it covers both electronic and paper-based formats. So what we call loosely materialised or immaterialised information. Okay. All right, so the first thing we would have to advise Bartolo is what documents will assist him. In other words, if we're going to access information, what kind of information does he want to get to? So it's a fairly practical question. It's probably a bit unfair in expecting students who maybe don't have much in government involvement, that might be some of you but not necessarily all of you, to figure out what the hell would actually assist our client, remembering that Bartolo is our mythical client. All right, I'm just going to list a few things based on my knowledge and experience in these sort of matters. Now, I've sat on selection panels when I've been in universities before. I've been in front of selection panels before, so I know what they're about in both the public and private sector. So sort of my wish list as to what you might want is you would want things like, for example, can you get hold of the successful applicant's application? Because you might want to see how did that person win and how did I lose? So you want to compare your application to theirs. So you want to see if you can get the successful applicant's application for appointment. You would also look at things like if there's a position such as this, will be selection criteria. So you want to have the selection panel's assessment or ranking of all of the candidates. So you might want to get access to that information. You might want to try and get hold of the curriculum vitae or resumes of all of the applicants for the position, because you might want to see, well, how did the winner or the successful candidate get up? What was good about his or her record that wasn't in mine? You'd want to look at referees' reports and also any references provided in support, that is from other people. And also you want to try and get hold of deliberative documents that the panel would have looked at when they were grading or ranking candidates, and perhaps working notes, jottings and scribblings from the part of panel members, and any formal reports or recommendations may be made by panel members to the chairperson of the panel. So they're all the kinds of things that you would want to get hold of in practice, and what you would need in one case differs from what it is in another. For example, in this barrister tender case I'm involved in for the provision of audit probity services. We made an RTI request that wanted to find out who the successful tenderer was, and not only that, we wanted to find out how were the selection criteria applied. So how did the losing tenderer not succeed? So in a sense, running in parallel to what we have here. All right. So
to get this information, do you need to have like identification, or
you mean
sort of identify, or
not normally?
any forms? Or?
Yeah, you do. Yeah, most government departments have standard forms that they want you to use in order to make an FOI request. However, it's generally not obligatory to use those forms, but the forms are designed to get the relevant questions framed properly. So you'd have to be a bit of a mug not to use a standard form if there is one, because it will make the decision easier as to whether or not you get your information. All right, so first thing is you've got to identify your relevant information. The second thing is you have to work out which statute you're going to use. Is it the federal one or the state one? I gave you some thoughts on that before. If the agency is a federal agency, you only rely on the Federal Freedom of Information Act. If it's a state agency, you then rely on the Right to Information Act in Queensland. So federal or state depends as to what kind of agency it is. Now, again, assuming that this is a federal agency, we then have to think about, well, okay, we've got the statute, we've got this wonderful, sexy FOI Act, 1982. How do we make it work? Well, this is when you trawl through the table of contents and you see, well, is there anything in here that helps me? And lo and behold, your eyes would light upon Part 3, which says access to documents, and that spans sections 11 through to 31. So, if we look at section 11, again, remember most statutes work on having general provisions that sort out certain rights or categories that we look at. And if we start with section 11, we see there that it says in sub 1, subject to this act, every person has a legally enforceable right to obtain access in accordance with this, access in accordance with this act to A document of an agency, or B, an official document of a minister, unless they're exempt. So we've got this absolutely fundamental legal right, a legally enforceable right to obtain access to documents. So when you see the words legally enforceable right, as budding lawyers, those words should cause joy to leap inside you, because it means that there's a pathway to getting something. Remembering that clients want results, not just effort. So we have here a legally enforceable right. So that must mean something. Now, although it's not the bee's knees to this question, there are in fact suggestions in some jurisdictions that right to information is in fact a fundamental human right. There's arguments to that effect. If you look at the chapter in Kane and McDonald on right to information, just trying to find it now. There is in fact some discussion, I think, I was reading it last night. Chapter 10, freedom of information, there are references there to some of the literature as to a right to access information being a fundamental legal right. In one or two countries overseas, it's in fact a constitutional right, so it's even higher up the legal food chain than a mere right expressed in a statute. All right, so for present purposes, note section 11, which gives you a legally enforceable right to information. Now, there's always for every exception, as we say in the law, there's often a rule, and for every rule there's an exception, I do beg your pardon. So we need to see whether or not there are any exemptions. Okay, so we need to, the way it works is Parliament giveth with one hand and taketh away with the other. The exceptions signalled or signposted in section 11 are, if the document is an exempt document, it need not be provided. So our reasoning pathway is this. What statute applies? Answer, FOI Act. Number 2, does Dr. Partolo have a general right of access to documents? The answer is yes. Look at section 11. The exception, which is your third point, are there any relevant exemptions from disclosure on the part of the government agency? that is the one, whoever's the Attorney General's Department appointing the Director of the Victims Compensation Board. We'll look at the exemptions in a moment. To come back to your question, Laurie, how do you apply for, or how does Dr. Bartolo apply for the documents? My earlier comments apply. Under Section 15 of the Act, you apply in writing for access. So you, under Section 15 sub 2, the request has to be in writing, and as I said before, most, I think just about all government agencies have standard forms that they use. And while we're at it, most government agencies have dedicated FOI sections that are staffed by people who know something about the area. Sometimes lawyers, not always, where those FOI officers decide FOI applications. So they're often pretty helpful to talk to. Terry, come in.
Yeah, just a question there. Under that Section 15, even though the departments may have standard forms, I don't see anything in that department that says you must apply in the standard.
No, that's right. It's normally those forms are advisory, not obligatory. But the reason why you probably would use the form is because it'll set out in a fairly methodical way the way that your request for information should be presented. And don't forget, if a standard form is being used, the decision maker is used to looking at the form. And so the questions in the form frame how you pitch your request for access to documents. So, look, I think you'd have to have good reasons not to use the standard form. Certainly you can't be refused access to information because you didn't use the form, unless there's a law that tells you you must use that form and that form alone.
Yeah, no, that was my question. Like, a officious bureaucrat couldn't deny you in the first instance on the basis you didn't use their form.
Quite so, no. But if your request was so higgledy-piggledy, a bureaucrat might say to you, look, your request is all over the place like a mad dog's breakfast. Why don't you use the standard form so that at least I can follow your request for information somewhat intelligently? So it's a practical question. Yep.
Hi, it's Aisha here.
Hi, Aisha.
I have a question in regards to allowing the release of other people's information. Like previously said before, that you may ask for people's resumes, the successful applicants' application, etc., etc. So surely if that was released, they would also blank out specific information? Yes,
they would, That really gets us into the question of what exemptions apply. Remember that the FOI system works on two principles. First, there's a legal right to access, but it's also qualified through what we call exempt documents. Now, the questions of exemptions are dealt with in Part 4 of the FOI statute. And again, just to anticipate where you might be going with that question, if you have a look at Part 4, perhaps even the table of contents, just to orientate you, you've got sections 31 capital A through to 47 capital J. Now, not all of those are relevant in any particular case, but you've got things like exempt documents, documents affecting national security, cabinet documents, law enforcement documents, public safety documents, legal professional privilege, material obtained in confidence, and various things like that. So
I looked at section 35. Would that
be? Yes. With section, well, actually, section 35 no longer exists. So be careful of the text you might have looked at, because the version of the statute I have omits 35 and 36 as part of the, I think, the 2009 reforms. 35 and 36 were actually taken out, and the effect of that was to strengthen rights to access to information. So just again, hence my comment earlier about just be careful about what material you're looking at or what version of the statute you have. Now, if there's stuff that is confidential, take for example, let's go back to our example here. for example, if somebody, if a referee provides a report in support of a candidate's candidature, should the referee's report be disclosed? Well, it's a bit hard to see why that referee's report is relevant to our friend Dr. Bartolo, because any referee is going to say that their candidate is wonderful and that their sun shines through the back of their head. So it's not really going to help you to get access, on my silly example, to referees' reports. But what might be more relevant to the application is the committee's adjudicative notes. That is, the notes it looked at in ranking candidates and as to why our otherwise well-qualified candidate was excluded from appointment. So we need to see whether there are any exemptions that particularly apply when it comes to the question of the classes of documents I referred to earlier. Possibly referees, to pick that example, referees might provide their reports in confidence. So have a look at section 45 sub 1, which refers to documents provided to disclose might amount to a breach of confidence. And have you all done equity yet?
No.
No, okay. When you get to do equity, which is a wonderful subject, you'll learn there about what we call the action for breach of confidence. And certainly that whole body of law basically tells you when things are confidential, which is supported by or reflected by the law, particularly an equitable thing. And I've certainly litigated a few cases about that over the years. Okay, so we need to consider, are there any other exemptions that might apply? And again, remembering that the statute has been amended. Now, I know the statute has been amended, but I'll just mention a couple of the former exemptions that would have applied. The first one is internal working documents under section 36, since repealed, and the personal privacy exemption in section 41, again, that's been repealed. But depending as to when, we're not actually told on the facts when these facts took place. So if you assumed that the facts took place, say, before the 2009 amendments, that's when you would in fact discuss sections 35, 36 and 41. So just be aware. All right, so my view is unless there is a right of, unless there's a good exemption, the whole premise of this area is to give people access to information. And so you need to be alert to the fact that generally speaking, there will be a right of access to basically the documents that are the subject of a specific exemption. So you really need to understand the methodology here. The first is there's a general right of access under section 11. And secondly, the general right of access applies unless there's a specific exemption in part 4 of the statute. So methodologically, it's really quite straightforward. Right of access unless exempt. It's sort of like one or the other. You're in either one, you've got a foot in one world or a foot in the other world when it comes to access to documents. Now, the state system might work a bit differently. I'm just going to try and, so I'll just find my Right to Information Act at the state level. It's not in reach, I'm sorry. But you look at that to see whether or not anything in the Queensland statute actually provides any different. So if you were answering this in the exam, you would, and you were assuming that the state system applies, then you might in fact come up with an answer that says, look, maybe it's a bit different under state law. All right. Now, the other thing that always needs to be considered is probably a more practical question than anything else, and that is, do the relevant documents exist at all, the ones that you might have put in your wish list? Because sometimes, and I've seen this happen in practice, is you might list a whole bunch of things in your Freedom of Information request, and the government agency comes back and says, those documents don't exist, therefore we don't have to give disclosure. So some of the skill in this area is actually working out what documents might exist in terms of what you list in your application. So that's always a question you need to be alert to. Okay, any questions about this? This is the kind of question, by the way, in an exam where you've got a fair bit of liberty as to how you answer it, but certainly I would be, it's a how-to question, so it's a fairly practical one. You go through the provisions of the statute that tell you your rights of access. You might talk about the important policy dimensions behind it, the notions of open government. And if you look at particularly Kane and McDonald, their chapter on freedom of information isn't terribly operational. And by that I mean it's not a nuts and bolts, oh, this is how you do it. So just be aware that chapter 10 of that book is more typical academic style. It's more policy driven and more conceptual. Certainly a good exam answer would refer to the policies and the conceptual apparatus. If you're wanting an operational account, the work I would go to is one of the other works I've mentioned from time to time along the way, and that's Bill Lane and Simon Young, Administrative Law in Australia, and have a look in particular at Chapter 4, where it's much more operational, and by that I mean it's much more nuts and bolts about how to do it, when do the exemptions apply, what do they mean, all that sort of stuff. So the two works... Can you repeat that? Yeah. The second work is W.B. Lane and Simon Young. The work is Administrative Law in Australia. One on my hot little hand is the 2007 edition. I can't remember if they've updated it since then or not. Certainly they haven't. Have a look at Chapter 4, where the commentary and analysis on freedom of information is much more operational or focused. So as a practitioner, I'd go to Lane and Young first, or any of the loose leaf services. But if I was tackling this at a conceptual level, I would start with I would start with Kane and McDonald, and then work my way back to the other work, which is more nuts and bolts. Just different emphases. There's nothing right or wrong about it. It's just that you just want to indicate how it would be approached. Terry, yep.
Purely academic question.
Yep.
Just looking at the objects, 3 and 3A of the Act, they talk about access to documents, but they also talk about, agencies publishing information. What's your legal recourse if you're chasing information that they haven't published? Like, how can you're seeking information that's not in a document, perhaps, but ultimately they had a duty to publish it under the general objects of the Act. Like,
yeah. Well, probably the object clause. The question in statutory interpretation terms is the object clause itself directly enforceable? The answer is no, and that's a general across-the-board proposition. So the object clause or a purpose clause in a statute generally doesn't give you rights per se. However, the existence of the object clause in a statute, and most of the modern statutes have them, it might be that it influences how a particular provision in the statute should be interpreted. So I've often argued object clauses in cases when I've said, look, the object of the statute reinforces the interpretation I'm contending for. And then you take the judge to the objects clause and say, e.g., there's, for example, an agency has a duty to publish information. Let's pretend I was in a case where this particular government agency hadn't published information. I might say, well, I've no idea how they work. I want you to, give a statutory order review under the JRA in order to make the government department publish this information. But that's more a political / policy question than a purely legal question. We come back to section 11, which talks about a legally enforceable right of access. And they're magic words for us lawyers in training, because when we see the words legally enforceable right, that, as I said before, should make our hearts leap for joy.
For the punter on the street, would there be an avenue to the ombudsman?
Yes, probably, yes. Now, the ombudsman is really concerned with maladministration or poor administration. So if, for example, a government agency hadn't published information that was meant to, that could be the subject of a report by the Ombudsman, whether the state one or the federal one.
Okay, thank you.
Yep. Okay, now let's move on. I think we've done as much as we can on problem 23. Let's move on to problem 24, and probably some of the same kind of thinking in 23 flows into 24. The difference is we've got a more elongated version of an FOI request. So let's have a look at that. Again, we've got our wonderful friends Makepeace, and we've got this question about access to information. Now, again, at the expense of boring you all stupid, look at the directives in the question. And I can tell you categorically, and I know this is going on YouTube later on, sadly in the final exam there will be students who will not have looked at the directive in the question, and they will answer a different question, and I will not be able to successfully grade them on that question to a pass level if you don't answer the question posed. So always look at the question. In this case, to be really explicit, the directive is Makepeace asks for your advice as to whether it may obtain relevant information under the Commonwealth and State FOI Acts, and if so, how to go about it. So that is the, if you like, that's the parameters we have to answer the question in. No point going off on the fairies or on a different conceptual plane and talking about all sorts of weird and wonderful esoteric things. You've got to be reasonably focused and deal with that question. All right, so that's what we have to give advice about whether it can obtain the information. Now, again, just to repeat myself, and again, I hope I'm not boring you stupid, when you ask about obtaining information, you've got to think about how can it get it and how can it be refused. So you have to argue both sides of the question. That is, can it get the information? Is there a legally enforceable right, yes or no? Or alternatively, if there isn't, then you have to deal with the consequences of that pathway. All right, now look at the question, and it says, Makepeace says, can it get information under the Commonwealth and State FOI Acts? All right, now we know that this problem is located in the federal arena. So the first, one of the first things you would do in answering this question is you would point out pretty categorically to the reasonable examiner that the State Right to Information Act is of absolutely no assistance to Makepeace. So that leaves only the federal statute. So at least it cuts down our work by half. That's the upside. All right. Now, the second, that's the first point you would make. The second point you would make is you would investigate the question, do the documents exist? Why are we asking that question? Let's go back to our facts. We are told that there is a cabinet meeting, and again, the cabinet exemption should sort of spark a few thoughts in your mind. And you are also told that there is a conversation between the Australian Prime Minister and the Caledonian Minister for Culture and Aircraft Production. Interesting portfolio, but never mind. And just be aware that there's this discussion that's recorded in the facts as to where it is. Now that's a discussion. We're not actually told how that discussion is embodied, and by that I mean how is that discussion recorded? And hence my question, are there documents that exist? Now, be aware what I said in the previous problem. The federal system works on access to documents. Now, the concept of documents is defined very broadly in Section 4, and it's also, there's the Acts Interpretation Act 1901 definition of documents as well, which is in pretty similar form. So you have to ask yourself, is there any evidence that this critical information is actually recorded in a document? So you have to address the question, is there a document that exists? Now, have a look at section 24 capital A of the FOI Act, because you have there a regime where it says in sub 1, an agency or minister may refuse access to a document if, among other things, the document doesn't exist. So you can't get access to a non-existent document. So the question presupposes or invites us to speculate that this cabinet leak that Makepeace has found out about, that somehow it is embodied in a document. And again, you have to make an assumption and make that explicit to the examiner. So the short point is, if there's no documents, there's no ability to have access to it. On the other hand, you might assume, just to cover your bases rather, that there is a document embodying this information, and of course be aware that the document, the conversation recording or evidencing this, the document evidencing this document, or the, sorry, let me start again. The conversation that's recorded in the problem may be evidenced in the document, but you also have to look at the context of the document, if it exists, and that is, it might in fact relate to Australia's international obligations. So you need to look at the exemptions in the statute to see whether or not there is an exemption that would preclude the documents being disclosed, assuming they exist. Now, I flagged earlier section 33. Have a look at section 33 and notice it says a document is an exempt document if disclosure of the document under this Act would cause damage to, among other things, the international relations of the Commonwealth. Is there anything in our facts that might shed some light on that particular element or integer? I'd welcome your thoughts. All right, now have a look at the reference to Telstra. Notice what the Minister for Culture says. He hoped that Telstra was still intending to tender for the contract for the reorganisation of the telephone system in Caledonia. Okay, so there's quite a strong suggestion that this document recording the veiled threat by the Minister for Culture might in fact be relevant to Australia's international relations. Remembering that, you know, the ability of a quango like Telstra to bid for international work might be very important. Might be important to its bottom line.
Could it be anything to do with the commercial activities of the government as well?
Yes, yeah, and that's a good question, Aisha. You might find that a particular set of facts might generate a number of exemptions, and if this was being litigated in the AAT or in a court, you might in fact find that the government advocate would say, look, we don't have to disclose this for, among other things, section 33, section 34 dealing with cabinet documents. There might be other grounds, 45, material obtained in confidence, and section 47, documents disclosing trade secrets or commercially valuable information. That's come up a few times in disputes where people try to get access to government information involving their competitors. So those sort of things do crop up from time to time. So yes, always be alert to the possibility that more than one exemption or head of exemption might in fact apply in a given case. Now, the other thing to also keep in mind in this problem is have a look at section 24. I referred earlier to 24 capital A, but look at section 24 itself. Now, section 24 enables an agency to refuse a request on basically workload grounds. So if you draft a request that is so wide that it might take an agency hundreds or thousands of hours to dig that information out, or documents out containing that information, you might find that your request for access is refused on workload grounds. And that particularly happens with what we call vexatious applicants who repeat their applications time and time again. And, you know, it would take a government agency hundreds, if not thousands of hours to respond to a request. I'm involved in a case at the moment where an individual made, I think, about 50 FOI requests to various government agencies, and in many cases the same agency over and over again. And by and large, his requests for access to information were refused on workload grounds. So just be aware that it's not necessarily smart for your clients to make repeated requests ad nauseum for documents. You might find that you get refused on workload grounds. So it's just a practical matter. So the point is, I suppose the moral to the story is think about your application carefully and try and get it as right as you can when you first make it.
Can I ask, is your client vexatious or does he have grounds?
Look, I think his FOA applications were vexatious. He was a bit fixated about the case, about the way he was treated by the Department of Education in Queensland. But he does have a ground for his substantive gripe is well-founded. He has been improperly dismissed from his job. So, yeah, he's ticked off. He's got a good reason for it, but he's a bit fixated. So this all happened before I got involved, because I wouldn't have advised him to make 50 FOI applications.
Mm-hmm.
I would have said make 1 or 2 and leave it at that. But look, you can give advice to people in life, but the reason why people come back to you in life is because they don't take your advice the first time round. It's a truism of life. Okay, all right, enough for the moralising. Let's get back to the problem. Okay, the question then is, how does it get the information? We make the request under section 15. We start off with the general right to information. We grant ourselves in the federal statute. We ask ourselves, do the documents exist? You need to give advice, in this case, about how widely or how narrowly should you frame your request for information. And generally speaking, be as specific as you can, because when you're specific in your request, and that's what you would advise Makepeace, the more specific your request, the easier it is for the agency to give you what you want. On the other hand, it's a bit like a parallel in the law governing subpoenas. If your subpoena is too broad, it can be struck out. Sorry, there's nothing at my end indicating.
Okay.
Yeah, I haven't moved my mic. Yeah, haven't moved my mic or anything like that, or moved around the room. Coming back, the point I was making, Laurie, is make your FOI request as specific as you can, because the more specific it is, the easier it is for the agency to respond to it. And again, just be very careful when it comes to workload grounds being a basis for refusing your decision under Section 24. Now,
just an operation.
Yep.
Yeah. When you're saying advise them how to make the claim, would this not be the point where you would actually make the request on their behalf?
Well, yeah, you would. As the lawyer, you would take charge of the process, and you would frame the application based on your knowledge of FOI laws and how you know documents exist or are created. If you're in any doubt, each department nowadays publishes a log of their FOI requests, and if in doubt, look at some of those logs to see how the questions are framed. It's the old thing in life: if you ask the wrong question, you get the wrong answers. If you ask the right question, you might get the right answer. Okay, so you have to balance in this problem, indeed in any problem in real life as well. You have to balance your right to information against any exemptions that might apply. So remember that Section 11 talks about documents being no disclosure if they're exempt. So look at the Section 11 signpost. Look here in our case at the international relations exception under Section 33, which I flagged before. And so if you're looking in particular at Section 33, be aware that the government is going to say that disclosure should not be made because it might cause damage to the international relations of the Commonwealth. So have a look at any of the grounds for refusal under Section 33, which are there are in fact four of them: security, defence, international relations, or information communicated in confidence. So either of those you would look at probably 33A sub Roman 3 and 33 sub para B would be the ones, and an exam answer would discuss those in a little bit of detail. You also need to be aware, remember that the discussions take place in there's a reference to Cabinet, so you also need to look at Section 34 of the statute and see whether there's any basis on which the Cabinet secrecy rules might apply. So you want to have a brief treatment of that. And again, the tricky thing about applying Section 34 in our facts is we don't actually know in what form this information is recorded. You know, it could be a file note from a bureaucrat who sat in on the meeting. It could be, you know, the minister's personal notes, his diary note recording the conversation. We just don't know. So that's part of the joy of the question is we don't really know what form the information takes. So if you're going to wrap it up, the first thing is Makepeace has to satisfy somebody that the documents exist. That is, are they in a materialised form? Even electronic doesn't matter, but that has to be considered. So that's the first thing. So look at sections 33 and 34 and see whether or not those two provisions exclude the application from succeeding. If your view is that there's a chance the application may not succeed, then you have to think about internal reviews. Then go to Part 4 of the statute and look at the possibility of internal review. And most of these things work on the basis that if a decision maker refuses access, then there's provision for internal review. And then, so look at sections 52 and following under Part 6 of the statute. Now, what's new, particularly with the reforms that were done to the statute in 2009 and 2010 is instead of going straight to the AAT, they interposed a character called the Information Commissioner. So under Part 7 of the statute, look at the role of the Information Commissioner and look in particular at section 54 capital F, which provides a signpost or guide to how it all works. And then it's only really after the IC review takes place that there's now more limited review by the AAT under Part 7 capital A of the statute. So a good answer would look at the review mechanisms because that's what we get excited about in this course. Okay, I notice time is marching on, so I want to move on to problem 25 briefly, which now, again, it always helps to be able to situate ourselves in a particular part of the legal universe, to use my favoured metaphor. And what we have here is the question of the Ombudsman. The question tells us very helpfully, for the purposes, well, it says the exam, but really this question, you are only required to know the provisions of the Federal Ombudsman Act 1976. Okay, so we have a problem, a situation for our consideration. Now, again, I'm going to harp on about it because it's really important. Look at the directives in the question. What does the question say? And and they're signalled by advise, consider, those sort of verbs or directive words. What we said here is to advise Ms. Raphael whether and how she can obtain assistance from the Commonwealth Ombudsman. So it's a two-pronged question. The first part of the question is whether, that is, can she get assistance from the Commonwealth Ombudsman. The second part of the question is how. In a practical sense, although we're not going to get overly excited about it, don't forget she's actually in prison, and her ability to do much is pretty limited because she's actually incarcerated. So just to be aware that there can be practical problems. There is in fact a prisoner's legal service. There are lawyers who will assist prisoners in doing these sort of things, and I'm sure, although I've never been involved with them, I have no doubt that matters of administration under the Ombudsman regime will in fact be assisted by the the prisoner's legal service. So that's just a practical side note. Okay. Now, when we're asked to advise Ms. Raphael, as I said before, you have to argue both sides of the equation. We're not doing our clients any good service if we say, yes, you've got an absolute rip snorter of a case, and give her glowing advice on prospects of succeeding, if at the same time you don't look at the reasons why they shouldn't succeed. So you have to look at reasons, the pros, if you like, and the cons. So a good exam answer will tackle both dimensions in the problem. All right. So when we come to the Ombudsman, apart from understanding what the question is focusing our mind on, the first question you have to ask yourself is an important one. Does the Ombudsman have jurisdiction? Okay, now...
Does it depend on the state or which government?
Well, yes, it is, yeah. That's right, yeah. Well, we're told on the facts, though. The facts tell us that we are looking at the Commonwealth Ombudsman. So we don't have to, in this problem, look at the state situation. If the facts were silent as to which agency was involved, federal or state, then we would need to look at that question. That is, does the state ombudsman apply? But we're told explicitly it's the federal, so that's where we situate or locate ourselves. All right, now, in general terms, the Ombudsman, I don't know if you've had a chance to read the chapter in Kane and McDonald. It's quite good from a policy or institutional dimension. If you're looking at it from an operational perspective, go back to that other work by Lane and Young. And I'm just going to tell you what chapter it is. I did have it marked a moment ago. Chapter 5. So look at chapter 5, which deals with the mechanical or operational elements. So chapter 5 of Lane and Young is more useful from an operational perspective than, for example, the corresponding chapter of Kane and McDonald, which is, I did that a moment ago. Where is it? Is it there at all? No, not there. Anyway, if they do discuss it, it's part of chapter 9. Look at section 9.3 from pages 245 to 256. All right, now, the Ombudsman is this this creature, this statutory official who investigates, and if you need to pigeonhole it, that person investigates Commonwealth maladministration. In other words, when administration goes wrong or pear-shaped. Okay, so the first thing you've got to find in a case is there an instance of Commonwealth maladministration? And to answer that question, what you need to do is you need to look at section 15. And section 15 sets out some of the reasons why the Ombudsman will do an investigation and then publish a report. So in terms of the mechanics, the Ombudsman first investigates and then he or she then publishes a report. So if you look at section 15, look at sub 1 and paragraphs A through to C. And it's things like the action, meaning the administrative action, is contrary to law, unreasonable, unjust, oppressive, improperly discriminatory, based on a mistake of law or fact, is wrong. So they're very broad criteria. All of those things would have a lot of case law associated with it, whether in this statute or in fact in other statutes. So it's not hard to figure out what it's really about. But basically, when you sum it up, the buzzword you want to use is maladministration, that is bad administration on the part of a government agency. All right, so let's look at our facts. Is there anything on our facts that indicates any kind of maladministration? So what we've got is, let's look at our facts. Sadly, Ms. Raphael is sexually assaulted. Her solicitor complains to the governor of the prison. Then 6 months later, nothing has happened. And we're told that the warden of the prison sits on their hands and basically let 6 months at least pass to see that the frivolous complaints are weeded out. And if they're serious enough, they complain again. She complains again. She hasn't made an application for victims' compensation, intends to do so. And of course, then what we're trying to do is find out through this extra legal avenue, can she get assistance from the Ombudsman? So we need to find out, is there anything that's happened which would indicate a reason why the Ombudsman should intervene? And I'll throw it over to you guys. Has anything happened on the facts that would activate or excite or attract the jurisdiction of the Ombudsman?
Has she gone to the department first?
Yes, she has. We're told on the facts she did. She complains to the governor of the prison, which is the proper channel.
Okay, well, surely the governor of the particular prison is not the final end game within the department of, for want of a better name, corrective services. No, but that person has, the governor of the prison obviously has responsibility for governance inside the prison, including what the employees of the prison service do. Yeah, I mean, what I'm saying is, like, she's received nothing from the governor. Could she then not go to the Director General of the department that looks after that?
Yeah, she probably could. If she hadn't heard in good time, she'd go back to her solicitor if she could, and that solicitor would go over the head of the governor. You'd go to the DG or Director General of the department, repeat your complaint, give them all the information and say, we want an answer pronto. So yes, in practical terms, you might do that. But clearly we're told anyway that she had approached, that the proper official in this case to approach when it comes to a prison is in fact the governor. Just be aware, it's not really part of our course, but you might see it in your readings. Certain institutions in society have what we call visitorial jurisdiction. You can get what we call a visitor appointed to a prison who will in fact investigate these sort of problems. It's a bit of an old English institution. Universities have visitors. I don't know if CQU does. I was aware that some of the older universities had them in the past. Anyway, that's an aside. All right. So is there anything though on our facts that indicates a reason why the Ombudsman would buy into this particular matter?
Well, isn't prisons, aren't they come under state jurisdiction?
Yeah, they do, but we're told on the facts that it's a Commonwealth prison. The reality is, apart from the ACT, all people convicted of Commonwealth offences are actually housed in state prisons. There's like a sharing arrangement. There's no, like you see in America, there's no federal penitentiaries in Australia.
Mm-hmm.
Would it first of all be relevant to look at the solicitor as well? And although the solicitor tried to arrange an examination, the prison authorities refused the request. So, I mean, obviously, well, hopefully that solicitor would do something about that.
Well, you would think so. Yep.
Yeah.
The prison policy seems a bit light on.
Yeah.
Sorry, the policy seems light on. You mean the policy that the governor has adopted?
Yeah.
Well, there could. Well, if you look at Section 15, there might be a suggestion that that policy is contrary to law. We don't know enough facts. There might, in fact, be either a common law or a statutory duty on the part of the governor to properly and promptly investigate assaults on prisoners. There might be something in the Criminal Code in Queensland or the Federal Criminal Code Act that obliges that. There might be a suggestion that a practice, that this policy or practice is unreasonable, unjust, oppressive, or improperly discriminatory. So that's a possibility. Well, the easiest one to hang your hat on is the one in 15 sub 1 sub A para 5, was otherwise in all circumstances wrong. I mean, it's just plain wrong, in my humble opinion, for a sexual assault against a prisoner to go completely uninvestigated. That is just one of the most derelict things I can think of.
It's not a frivolous complaint.
No. That's right. I mean, if she was complaining every day of sexual assault when in truth she hadn't been, well, that's a different story. You can ignore frivolous complaints. But I mean, this isn't the case. There's no facts that enable us to say that poor Ms. Raphael is being vexatious.
She's not whinging about the ice cream in the kitchen.
No. Or the yeah, that's right. Or the fact that the laundry is the wrong colour. You know, nothing like that. She's been the victim of a criminal offence, and of all things, that should be examined most carefully.
Sorry, I was just going to ask a question on that about offences of a criminal nature in respect of the Commonwealth Ombudsman.
Yeah.
I was a bit confused on this. What is the relief that the Commonwealth Ombudsman, other than of perhaps a procedural nature or to prevent these type of administrative issues with people reporting crimes and reporting of it, I don't think there's anything they can do to sanction or to, isn't that for the DPP really?
Well, in terms of the criminal sanctions, you're right, it is for the DPP to follow up. But what might happen is, have a look at Section 16. So let's pretend the matter is investigated, and under any of the grounds I've mentioned, the Ombudsman decides that it has jurisdiction, which it would have. Then what happens is you move from Section 15 to Section 16, and there you have the Ombudsman can make a report. So the Ombudsman makes a report, and actually it makes a report under 15 sub 2. And if you look at the detail of 2, the Ombudsman can make various recommendations. So they report to the department. Might be, the Commonwealth Women's Prison Service would receive the report, and the Director General of that department, or whatever they're called, the Secretary of that department in the federal arena, would be expected to look at the report and then properly have all those matters investigated. So one of the criticisms made of the Ombudsman is that he or she has no real adjudicative powers. They can't make something happen. But if something doesn't happen, then it can actually get escalated. Look at Section 16. The Ombudsman can do certain things if appropriate action is not taken on the Section 15 report. Under 16 sub 1, the Ombudsman can notify the Prime Minister in writing. That's pretty serious. And not only that, you can also write to the Parliament, the President of the Senate and the Speaker of the House of Reps. And then in a special case, you can, in Section 17, you can table a report that maybe follows up instances of maladministration on the part of the government. So it all rests on what we call powers of persuasion, and also what else is a word I'm looking for? The blaze of publicity. So if something is tabled in Parliament, for example, a special report, that's now a matter of public record. So do you think the governor of the prison wants a report that says that he or she failed to investigate an assault on a prisoner? I wouldn't want that on my watch. So obviously there would be, it works on what the sociologists call shaming.
So what about the actual relief that the Ombudsman can provide other than just sort of an adjudicative report, so to speak? I mean, can't do
anything beyond that. It's a bit of an unusual creature, the Ombudsman. All they can do is make recommendations. They might make recommendations about the payment of compensation, investigations. They might involve the DPP and all that sort of stuff. But basically, their roles, if you want to sum it up, their roles are advisory and recommendatory only. They've got no adjudicative sanctions they can impose.
How does that sit with inquests, so to speak? I know you often hear
an inquest is a very different thing. It's actually, an inquest is an investigation, an inquisitorial investigation into the commission of a crime.
Moot point outside the question, but was a sexual assault reported to the police?
Facts don't tell us.
No. Because it's still.
For example, the Ombudsman could recommend that the governor of the prison forward the paperwork to the DPP and or the Australian Federal Police. There are some things that can happen, and sometimes they're a bit more powerful than pure legal remedies, at least to get things moving along.
But she could report it to the police in her own right too.
Of course she can, subject to the practical difficulties of what do you do if you're incarcerated in a prison.
She's got a solicitor there.
Yeah, that's how a solicitor should be. I mean, a solicitor would, I know our facts are a bit sanitised, but things would actually move along quite a bit faster in a case like this.
Yeah.
Now, the other thing you would advise Ms. Raphael is to lodge an application for compensation with the Victims' Compensation Board. But usually most of those, I don't do a lot of work in that space anymore, but normally you have to have a conviction against somebody who's convicted of the crime of sexual assault. You normally have to have a conviction first, and then after that the Commonwealth then pays compensation. So you have to have gone through the whole investigating the crime, reporting it, the DPP deciding there's enough evidence against the wardens, assuming you get through that, then you have a trial, there's a conviction, then but that's a long drawn out process. It would take literally years before poor Ms. Raphael would see any compensation from that Victims' Compensation Board.
Will they get any interim compensation?
I think you can. Again, I don't pretend to know much in that space anymore. I haven't done any work in it for about 8 or 10 years. I might be wrong because I don't know enough about it anymore. Last time I looked at the Queensland system, I don't think there was provision for interim compensation, but I stand to be corrected. You'd have to look at the, what do they call it now in Queensland? Victim of Crimes Act. Can't remember what it is. Again, I profess ignorance. Although I do a lot of work in a lot of areas of law, I don't really do much in victims' compensation law anymore. All right. I want to move on and briefly consider 26, which is the last question before we'll leave each other tonight. Okay, the question is, thankfully it's really simple, but the answer is actually complicated. The question, put very simply for problem 26, is how do the courts approach ouster clauses? First thing we need to do is get our definitions right. So an answer to this question, were it an exam question, is you first have to define an ouster clause. Now, the other sexy word for these is privative clauses. If you are looking at the standard texts, there's a good treatment of privative clauses in Chapter 7 of Kane and McDonald. Now, in the other work I have looked at from time to time, Lane and Young, so I'm just trying to find it. I had it flagged a moment ago. Sorry, I'm just trying to dig it out. What have I done with it? Sorry about that. That's just my phone going off. Can't put my finger on it at the moment. It'll come to me as I go through it. Now, there's another good little treatment in another work that I've referred to from time to time. It's a book by Francisco Esparraga, that's E-S-P-A-R-R-A-G-A, and Ian Ellis-Jones. And there's a good little treatment on privative clauses in Chapter 8 of that work. And if you can get to it in the library, have a look at pages 193 through to 201, so 193 to 201. Now, what I'll probably do, I don't think I'll be breaching copyright. What I might do is get those pages scanned, and then I'll flick them around by, upload it as a post. So I'll try and do that. So if I haven't done that in a couple of days, would one of you be kind enough to send me a reminder? There's a lot of things on my head at the moment. Again, sorry, that's my stupid phone going off. They can all do without me. Okay. All right. Now back to privative clauses. All right. In terms of approaching this in terms of exam technique, how do the course approach ouster clauses? The first thing you need to do is you need to define what an ouster clause is. And basically, and I'm quoting from Esparraga and Ellis-Jones. Their definition on page 193 is this. An ouster clause is an attempt by the legislature to prevent or otherwise restrict judicial review of administrative actions. So it's an attempt by Parliament in legislation to exclude some kind of judicial review of administrative action. So that's the first thing to keep in mind. Now, the next thing you would need to answer in this is to actually give examples of or identify the types of ouster clauses. And again, because I think this work is pretty useful, and you'll see it when I send around the excerpt from the book. The types of privative clauses are, for example, time limit privative clauses. That is where it gives a time frame for something to be done, and so be aware of that. That's the first one. The second category, I'm getting a bit irritated with this. I think it's one of my colleagues trying to get hold of me. All right, the second type of privative clause is what we call a finality privative clause. I'll give you an example. Finality privative clause reads something like, a decision of the tribunal shall be final and shall not be subject to any appeal in any court. So it's an attempt to make the administrative decision the last port of call. And a third category is no certiorari or shall not be questioned clause. A no certiorari clause reads something like this. A decision of the tribunal or decision maker shall not be quashed or called into question in any court whatsoever. So it's trying to exclude judicial review, obviously by a court. There's another type of privative clause known as conclusive evidence privative clause. An example of that is in the tax legislation. For example, Section 75 of the Income Tax Assessment Act 1936 says, and I quote, the validity of any assessment shall not be affected by reason that any of the provisions of this Act have not been complied with. So that's an example of an evidentiary privative clause. Yet another example is what these commentators call a ground limit privative clause. it says, they describe it as one where the clause seeks to restrict the availability of some or all judicial review remedies, saying things like, this decision shall not be quashed, reviewed, called into question, or whatever. So the common thread to all of those examples is it's an attempt by Parliament to tell the courts to butt out of giving judicial review. Now, you might wonder, why the hell does all this stuff matter? And the answer is it comes back to some of the very great tensions that exist between Parliament and the judiciary. And remember that under the Australian constitutional framework, it's a tripartite one resting on separation of powers. The first thing to keep in mind, and you would mention this in your answer, is Parliaments enact laws, the executive implements laws or applies them, and the judiciary interprets and administers disputes concerning laws. So there's a threefold function. So what you have to keep in mind is it starts with separation of powers, and it's an attempt, it's basically a bit of a turf war between courts and Parliament, or in other words, between the legislature and the judiciary. So as long as you situate that institutionally, all this stuff makes a little bit of sense. All right, now, you could answer this question very simplistically. It wouldn't answer the question completely if you recognise that the first thing you have to keep in mind is that the courts, basically, the courts are hostile towards ouster clauses. And basically, it's more my thinking rather than what any other commentators say, what courts do is that they do anything they can to get around, or the American expression is end run, to run around ouster clauses. So if there's a weakness in the drafting of the clause, clever judges will have the intellectual machinery to in fact circumvent it. Now, if you go to Kane and MacDonald at chapter 7 of their work, they say, and it's quite a good treatment of it. It's a conceptual approach, so it's not overly operational, but you do need to be aware of the conceptual apparatus because that's really where this goes. Now, the first thing to keep in mind, and have a look at page 189 of Kane and MacDonald, is we have this notion of what they call the entrenched minimum provision of judicial review in Australia, and that comes from the constitutional side of things in section 75 sub 5 of the Constitution, which basically you might remember from previous study in this course, it sets out when the constitutional writs are available as against an officer of the Commonwealth. So the leading case here, which would need to get some treatment in your answer, is that you have to look at that case of Kirk and the Industrial Court of New South Wales, which is a 2010 decision reported in 239 CLR 531. And basically, if you look at footnote 9 on page 190 of Kane and MacDonald, they say there, Kirk held that all state Supreme Courts must maintain a supervisory jurisdiction to review for jurisdictional error. So in other words, that's been a very important decision because it says that if the High Court is going to be the ultimate court of appeal from state Supreme Courts as it is under the Constitution, then you can't interfere in what a state Supreme Court does and prevent it from having the ability to review decisions made by, for example, administrative decision makers in the states. So what Kirk's case did was to create a level playing field when it comes to state courts and the federal courts on the question of what they call constitutionally protected judicial review. So that's quite important. Okay, and Kirk's case is discussed at page 190 in a bit more detail than I'm going to go through now. Now, so that's the conceptual or the institutional approach. The the next thing you need to be aware of is that later case of plaintiff S157. Now, what it says is, and it's treated at 193, for example, of Kane and McDonald. What that case says is that it basically constitutionalises the question of how the High Court can attack a privative clause. Now, this is where I think Kane and McDonald have a good treatment of it. What they basically do is this, and if you strip down what is said at pages 193 to 195, basically they're saying this in very simple terms. They're saying that the High Court is trying to find a balance between allowing privative clauses to work, but at the same time restricting them so that they don't prevent access to justice. See, if we've got this notion of open government, that is, governments are meant to be accountable and transparent, then judicial review is a mechanism of open government. If you have a privative clause, however, that impedes or intrudes on the notion of open government and general accountability. So the upshot of it is, how does the High Court balance it? I'm just going to keep turning them off. It's their problem. Sorry about that. So we have to find this balance. So what we do is in Plaintiff S157, which was once again a Migration Act case, they basically say this: you read down a privative clause, particularly having regard to the constitutional safeguards. Now, an earlier case they discussed called Hickman's case is a case where actually they don't, the High Court has never really per se struck down a privative clause, but what they have done is they've rented them down in such a way that they have very limited room to move. And that's what you need to be particularly mindful of if you are answering this question is the Hickman doctrine is sort of, that's a decision of Dixon and a few other judges earlier last century. They basically recalibrate Hickman and say that basically we've got a situation where we will basically restrict the operation of the privative clause. So that's what you need to take account of. In terms of this concept of the entrenched minimum provision of judicial review, have a look at page 196 and 193 through to 198 when it comes to that text, because there's a good treatment there. So if you were going to sum it up in an overall way, the way that courts approach ouster clauses is first with hostility. The second thing they do is, in extreme cases, they will strike them down, and they will get struck down on the basis of inconsistency with minimum standards of constitutional review. And by that they mean the constitutionally protected judicial review that flows from section 75(5) of the Commonwealth Constitution. The other thing that flows from it too is the state, the ability to have effective privative clauses at a state level is also affected by the P157 doctrine, and that other case I mentioned, Kirk, where they've integrated state Supreme Courts into the federal constitutional apparatus, saying that the High Court can't effectively review state courts if those state courts are themselves impeded from exercising a proper supervisory jurisdiction. So that's been quite an important development in understanding ouster clauses. So that's probably the way I would tackle that particular question. All right. Now, I'm sorry I've taken you over time. It's 8:20 on the Play School clock at my end. I might just wrap it up there if I may. I have no idea why 58 people are trying to call me at the minute. I don't know if some alarm has gone off in my chambers or something like that, or some such thing, but I might just leave it there. This, of course, will be uploaded to YouTube, and then I'll probably be uploaded tomorrow. It takes about an hour or two for the recording to be uploaded, but it should be available. And what I'll do is I'll I'll get the YouTube URL and I'll flick it around through the notices forum that we use. I'll also get an exam notice out as well, and I'll also consider whether I'm able to put on perhaps not an exam review session, but more a question and answer session closer to the exam, maybe a few days before the exam, but not the night before. So I'll just have to see how things pan out for me in terms of my timetable. So thank you very much for your attendance, and if you've got any questions after all this, either give me a call tomorrow or flick me an email, and I'll do what I can to share my wisdom or pull my ignorance, depending as to how you want to cover it. Okay, I'll leave it at that.
Thank you.
Thank you for attending, and we'll be in touch electronically, no doubt. Okay,
Thank you.
Good night, everyone.
Bye.
Cheers.
Good night.
Bye-bye.